Kia ora koutou. Welcome to the Beca Wharanui. E reri haere ana ngā mihi nui ki te mana whenua o te rohi nei. Ki ngā iwi o Ngāti Whātua Ōrākei tina koutou mō te koutou manaakitanga I tēnei wā. Just recognising the mana whenua of this place that we're on, sitting at the top of Hobson Street, Governor Hobson being a significant part of the history of Auckland and the arrangements that were made with Ngāti Whātua Ōrākei. I'm really pleased to be able to introduce today's session. I'm Andrea Rickard here at Beca, and real soft spot for RMLA and what RMLA does, having been on the National Committee. So I think it's about 7 or 8 years ago that I stepped off after a period of about 9 years on the committee, and it's fantastic to see the strength of the organisation going forward, and a huge thank you to the committee for putting this on. Big welcome to you, Judge. Great to have you here today, and also to your co-speaker today from the EPA. It's a real pleasure to be able to introduce Mike Duisberg, who's going to run today's proceedings. Enjoy the day, and I'll hand over now to Mike, who's going to take us forward. And Mike is the chair of the Auckland Regional Committee. Thanks, Mike.
Tēnā koutou katoa. Thank you, Andrea, and thank you very much, Beca, for hosting us today. Without the generosity of firms like Beca, it is very hard for us to do these events, so thank you. Before I get on to introductions, I do just have one matter of housekeeping, and it's for the people that aren't in the room. If you're watching on the live stream, you should have the ability to type in questions. I think you can put in comments as well, but don't do that. I'm going to ignore those. If you have a comment, if you have a question, please do send it through on the app, and we'll deal with those at the end, as well as have the opportunity to ask questions from in the room. And I've got a mic, and I'll walk around and do the MC thing. So look, so you hear from me as little as possible. I'll get straight on to the introduction. So the first one is a man who really does need no introduction, and we probably say that more than is warranted, but this truly is one of those men. Judge Newhook has more than 50 years of experience working in the field of environmental law in New Zealand and internationally. 23 of those years, it's quite a big number, isn't it, spent on the environment bench as an environment judge, and 9 of those were as the head of the bench. Most recently and most relevantly for this presentation, the judge is the convener of panels under the COVID-19 Fast Track Consenting Act, and he still wears multiple hats and serves in multiple roles. Another one of those being as the commissioner of the freshwater hearings, the freshwater process, delayed but not stopped. One other observation I have, and I might get scolded for this one later, but the 9 years that the judge spent as the head of the bench were as the principal environment court judge. When Michael Jordan retired from basketball, the Chicago Bulls retired the number 23. It is very interesting that when the judge retired in July 2020, the name of the head of the bench for the Environment Court was also changed to the Chief Environment Judge. Just an observation that I'll leave there. Our second speaker is Elliott Dennett, who's the team leader of Fast Track Consenting at the EPA. Elliott has served 3 years and 8 months in that role, but who's counting? And before that, he spent time in the UK. We worked in the UK as an environmental advisor working on large projects. Who better to talk to the intricacies and the detail of the fast track consenting from the EPA's perspective than the man whose job it is to keep the process running smoothly. With that, I will change the technology to get the slide up, and then here we go, and then here we go. And with that, I'd invite you to please join me in welcoming Judge Newhook to the stage.
koutou katoa. Thank you for that kind welcome, Mike, and Andrea as well. Nice to see Beca people here in numbers. I've had a lot to do with people from Beca's over many years before I went on the bench and then since. So nice to be here and nice to rekindle some acquaintanceships. Many of you in the room I can classify as acquaintances or even friends. Numbers of you have chaired or been on panels under the COVID-19 recovery fast-track system, and it's nice to see you here. Some of you lawyers have provided legal advice to panels, and to me. I've taken a few opinions, and so a couple of you are here. When the curly questions come at the end of my presentation, I'm going to hand those over to the experts in the room. I warned Matt Allen particularly just a while ago, so he's shaking his head, but you won't get away with that, Matt. Now, what I'm going to do is to introduce the two parts of my address. The first part, I warn you, is deadly dull. Perhaps fire up on the coffee or something like that to keep yourself going. I'm going to try and skate through that as quickly as I can, but I do need to offer you that as an introduction to the slightly meatier later part of my address, where I'm comparing the existing legislation and the bill. I need, in my position, to remain relatively uncontroversial, and I'll do my best to stick to that. And you may find that some of the questions might want to take me into an area that I really can't go. But let's fire into it and talk about the existing legislation where I've been the convener for 3.5 years, nearly 4 actually, and where I'm offering some contrasts, some comparisons with the new bill, and then we'll get into some discussion about the new bill. So. And my paper, I believe, will be available to you electronically later on. So you needn't scribble. Just listen to me. In part, the first section of my address is taken from a document that many of you, will be familiar with, having worked on panels. When I took up the role in 2020, I felt that the Act, which had been drafted in some haste, skated all over the place. You know, you were looking at sections of the Act, and then you were in Schedule 6, and then you were in Schedule 5, and back into the Act, and all over the place. So I wrote a document that I cutely called the Navigation Guide to the Act. And I'm told, perhaps people just being nice to me, but I'm told that panels have found it quite useful. I prefaced that guide, and I preface what I'm going to say today about both the Act and the bill, that I'm not giving legal advice. Don't hang on every word. Don't believe anything I say, perhaps. It's probably good policy. The navigation guide and my address today are intended strictly as a guide. Work things out for yourself. Now, the next part of my address is headed Legislative Contexts. And in that, I go into the purpose of the COVID Recovery Act, which essentially was designed to assist the then anticipated severe economic consequences of COVID and lockdowns and the like, which mightn't have actually arrived quite to the extent that was feared. And then I contrast that with the purpose of the bill, which is completely different, and I'll read that to you quickly. It's to provide a fast-track decision-making process that facilitates the delivery of infrastructure and development projects with significant regional or national benefits. And I note as well that Clause 1, Subclause 2 of Schedule 3 of the bill about the work of expert panels prioritises that purpose above considerations under relevant legislation. So it's the top of the pops. So that's one of the more notable differences. I will take you through some others in the course of my address. So let me see how I'm going to try and summarise a good deal of what I'm saying about the current legislation, because it'll be quite well known to you. But for the purpose of being able to contrast its provisions with some of the bill's provisions, I've got to refer to some of them. The Treaty of Waitangi features in the Act. There appears to be a legislative policy since the change of government that doesn't get swept up into acts. There are references, quite liberal references in the bill, to various Maori and Maori cultural issues and land ownership and settlements, Waitangi settlements and that sort of thing. But there is no express reference to following the principles of the Treaty of Waitangi and treaty settlements in the bill. Section 6, in contrast, in the current legislation, is a step above Section 8 of the RMA and places considerable importance on it. Section 10 of the Act is important, and there's an element of it in the bill. It says and it applies to all persons performing functions and powers under the Act. Everybody is required to take all practical steps to use timely, efficient, consistent and cost-effective processes that are proportionate to the functions, duties and powers being performed. Later in my address, I'm going to talk about some of that kind of work and ask some reasonably searching questions. As to eligibility for fast-track consenting, I wrote a fair bit about that in my navigation guide, and I don't need to go into that today because the work of ministers is concluded in relation to the current legislation, so I don't need to go into that. I'm going to hand over to Elliott now for a few moments to talk to you about the functions of the EPA in supporting me as convener and supporting panels.
Kia ora. I'm Elliott Dennett. I arrived in New Zealand about 4 years ago, and after lockdown, I ended up doing a little bit of fast track, and this is, I guess, where we've ended up. So I assume most people who are watching has probably either been involved in fast track from a panel perspective, or an applicant, or a special advisor. But I guess it just shows the impact that fast track has had since this has started. And for us at the EPA, COVID particularly, it's kind of been a snowball effect that's kind of just increased in workload since we've originally began. So I thought I'd initially just start off by just giving some facts as to where we are today specifically with COVID. So the Act was repealed last July, and there was the sunset clause in there that allowed applicants an additional 6 months to lodge, so the 11th of January was the cut-off date. So to date we had 120 applications, and it's probably worth saying that 40 of those came in the last 3 months of the end of the process. So as you can imagine, that was quite a considerable push and effort. 15 of those were listed projects, so again, I think we may talk about listed and referred projects later, but hopefully a lot of you already know that information. 105 of those were referred applications. 72 of those have been decided. We've had 66 approvals, 5 declined, and 5 that were withdrawn or deemed ineligible. And that was just one situation where I think the legislation, the policy changed, and the activity then became a prohibited activity, so the panel could no longer take that through. We're currently processing 44 live applications. That's 44 applications left, which is good news, I guess. But alongside that, we've also got the NBEA, the Natural and Built Environment Act, which is still ongoing. So applicants can still lodge under that legislation for referral, and then obviously going forward from there. The new bill seems to indicate that any applicant that's lodged under the NBEA application, that will just carry on until a decision is made, which is an interesting, I guess, dilemma for applicants to decide whether to wait or whether to lodge under the current repeal legislation. And then I guess I find this one probably the most interesting, but upon completion of Fast Track, we will have had approximately 370 panel members that have gone through, not different, but that's a lot of people, and then I've not even taken into consideration the kind of special advisors that we've had and everyone else that's been involved in Fast Track over the years. So that's coming up to 4 years in the process. Yeah, just in regards to locality, as you can imagine, Auckland, we've had 50 applications, which has been the majority. In second place is the Otago region with 15 applications, and third we've had Wellington, which had 12 applications, and then obviously there's a lot of other regions where we've had applications up and down the country, but it's been very much a nationally had a national effect. I'll just quickly kind of cover the role of the EPA. So we provide secretarial support in lots of different capacities. I kind of describe Fast Track for us on a day-to-day basis in two kind of segments, or maybe three. We have the kind of pre-lodgement and lodgement stage where the EPA engage with the applicant, kind of get them ready to lodge, provide some kind of support around that and what they need in regards to the process and what that looks like. In addition to that, we've then got the actual lodgement itself. The lodgement itself is quite a short period of time, so as the EPA we do a tick box assessment to make sure that all the information that's in the legislation has been provided. We have 5 days to turn that around, so you can probably see why pre-lodgement is quite important for us. 5 days to kind of look through the application, pull out all the information and get sign-off internally is quite a challenge. After that, we go into the appointment stage, which we work with Judge Newhook to invite nominations and to obviously go on to help the judge appoint panels and stand them up. From there on, we kind of get into the second stage of the process, which is a little bit more, I guess, chaotic sometimes for the EPA in regards to it goes on to the panel members. So every panel is different, every application is different. There's lots of different challenges that come up from each and every one of them. So you kind of don't really know what to expect on a day-to-day basis. And some applications go through very, very smoothly within the first 25 working days, which is quite an achievement. And then obviously others have challenges along the way that need to be dealt with in a very, very fast time frame. So yeah, I guess the first thing we do once panel's appointed is the invitations to comments. We assist and provide some advice to the panel around who to invite to comment. Obviously that decision sits with the panel as an independent panel, but they decide who to invite, obviously following the guidance of the legislation. And once those invitations to comments go out, that kind of starts the clock. Starts the clock going, really. People have time to comment, and then we get into the consideration phase, which tends to be that deliberation phase, which is quite interesting. And that's kind of where the panel get into the nitty-gritty of the applications and figure out what they want to do. So during that time, they often do a site visit, further information requests. We tend to be getting a lot more suspensions than we have previously, which is where the application is put on hold for up to 50 working days. And that tends to be so the applicant can have a bit of breathing space to fill some information gaps or to find some information that needs to be filled in. If the panel are going to decide to grant the application, they'll need to invite comments on draft conditions as well. So that's another thing that they need to do within that 25 working days, which again is another challenge. So they need to draft those conditions or make sure that they're in a good state so everyone can comment on them and have some meaningful interaction. And then once we've got to that stage, then we go on and follow on to the decisions, etc. So as part of that process, I guess the EPAs provide advice where needs be. We provide administrative support. We also go out, as I mentioned before, and look for kind of special advisors, help with the kind of recruitment and contracts around those. So special advisors or technical advisors that the panel may need to kind of get that job done as well. So yeah, we assist with that, and then obviously all the other administrative tasks. So invoicing, which is obviously very important for people, making sure that everyone gets paid and the money goes to the right places. Yeah, support to the panel. As I mentioned, we've got the kind of completeness and pre-lodgement, which happens prior to that, and then help with any site visits as well. And yeah, just working through that process, anything that the panel needs, that's what we're kind of there to provide. In addition to kind of keeping track of all the records and updating the websites and making sure that everything's kept on track with that as well. So I think that's everything that I've got at the moment. So do you want to pass back to you, Judge? Thank you. Wonderful.
You might get the feeling that I and the panels are well supported by the EPA. I'm very grateful to them. They're a bunch of very skilled people, and we're very lucky in that respect. And hopefully that can carry over into what's going to be the new regime. I'm going to be able to move quite quickly through the next few bits of my paper because thankfully Elliott's actually done part of the job for me. I'll spend a moment or two talking about the convener, currently myself. And largely I'll describe the existing provisions because there are some differences but not many in the new bill. So currently the Minister for the Environment is to appoint a current or former Environment Judge to be the panel convener. That's been expanded to include potentially High Court or retired High Court judges in the bill. I say in my address, in my paper, when you read it, the description of the function of the panel convener in the legislation is seductively simple, but the devil might be very much in the detail. Generally, we're setting up panels with 3 members. The Act does allow for 4 in situations where there are big projects. I think we've only done it once or maybe twice. Generally, it's 3, and in my decision that I have to sign off a decision every time I appoint a panel, I record that if there are other matters, topics within a particular project that need more specialist input, the panel can turn to specialist advisors, as Elliott has indicated. And so it's my expectation that will usually round out the available skills for panels. The legislation is worded in an unusual way. It was possibly a bit of a sell, I don't know. The provision is in there for judges or retired judges to chair panels. But in the alternative, if circumstances require it, senior specialist lawyers. There are only 2 judges or retired judges who've actually chaired panels. I've done 5, and Judge Thompson did a couple. No, he did one, I think. They're simply not available. The courts have backlogs, they're over busy, under-resourced, and I cannot get my hands on judges or retired judges. So almost invariably, I'm turning to the legal profession to provide senior specialist people, and that's what's been happening. Interestingly, in one of the 2 judicial reviews that I faced as convener, an allegation was made that I hadn't done my duty in not appointing a whole lot of judges to panels, including the one that was the subject of those proceedings. The High Court judge in that case made very short work of that allegation, as indeed she did about the rest of it, I'm happy to say. The work of the expert consenting panels, again, Elliott has largely dealt with, and so I'm going to move right on over that. There is a portion of my paper which is a little over a page long and is very detailed, and I'm not going to address in any detail at all, but it is important for you to know that it's there. It's the reference to official information legislation, particularly Lagoima, and there have been some instances of requests under Lagoima about panel work, about panel deliberations, and there was a period of time during which senior management of the EPA and I had our differences about whether the information belonged to the EPA or to panels. We eventually resolved that in a way that I describe in my paper and is also described in some detail by way of an addition to my navigation guide that I supplied after we'd had that particular instance. In practical terms, it comes back to a question of whether the EPA will supply a staff member to sit in with the panel when they're deliberating and to run the Teams or Zoom technology and record things, because there's an express requirement in the legislation that the proceedings of panels must be recorded. So in my paper and in the navigation guide, I provide some practical guidance as to what panels might want to do. I think, by and large, Elliott, they're actually continuing with the practice of having the EPA staff member in the meeting with them, the virtual meeting, and recording things, and relying on the past situations in which the EPA gave an answer to the people making the request under Lagoima that it wasn't in charge of the information, and so people couldn't have it. The next section of my paper is again in considerable detail. It's about the core work of the panel under the existing legislation, and I'm not going to take you tediously right through it. I will touch on one feature, however. Like the existing Act, the bill makes provision for people to be invited to comment within 10 working days. I will return later to this period of 10 working days and how that works or maybe doesn't work in some ways. But for the moment, I'll just simply alert you to a practice that I developed. I chose to chair the first of the fast-track panels, a case called Matawi. It was about a water impoundment facility near Kaikoi in the north. And we panel members discussed the 10 working days and in particular the ramifications of the fact that some people don't have computers, and so things have to be mailed to them, and then they mail things back. And so I devised a procedure whereby 15 working days were actually allocated for people to make their comments to accommodate the people working on paper who couldn't address things or couldn't receive copies of the application electronically, let alone send their comments in to the panel. I think Panels have reasonably routinely adopted that procedure, and I think it's worked. I think it's brought a little more fairness to the process. There's a section of my paper where I describe the differences between the listed and the referred projects under the existing legislation. I think there were 17 listed projects in Schedule 2, I think it is, of the existing Act. 15 of them are still coming to us. The ability of panels to refuse consent is extremely limited in relation to listed projects, a bit like the scene in the bill. And it's really essentially confined to potential treaty breaches and to Section 104D, prohibited activities, in the case of listed projects. Elliott touched on the technique of suspension, and he mentioned correctly that suspensions are being sought by applicants to a greater degree, sometimes I think as a result of suggestions from panels. So when it's perceived that there's an awful lot of work needing to be done by a panel, and for instance many requests for further information are being sent out by the panel to the applicant and to councils, often there's a considerable volume of material comes back and needs to be woven into the overall decision-making process, and the clock is ticking and it's all getting really quite hard. So some of the projects have gone into suspension, which, as Elliott said, can be for up to 50 working days, simply to let people catch up. Now, there is a bit of a twist to the tale, and that is that the way some people read the legislation, it may be that the panel can't bill for its time during that suspension. It looks, on one reading at least of the provision, that it's a down tools exercise, and so all that's going to be achieved is that the panel will have a breather while the applicant goes away and does a whole lot more work. However, there is another way of reading the provision which some have been using, perhaps a little bravely, to actually keep the thing going so the panel keeps working, and I think they've been paid. This is a feature of the bill as well, and it could do with some legislative attention, I think, in the next phase of processing of the bill. Finally, before turning to a closer examination of the bill and offering some comments and asking some questions, I do want to point out that in the Act and in the bill there is a potential fishhook that legal advisors are no doubt bringing to the attention of their clients, particularly in the case of the bigger projects, and that's the lapse provision in the RMA, as you know, 5 years unless something else is specified. In this legislation, under Clause 37 of Schedule 6, it's 2 years. And I understand that some potential applicants have balked at that. Some of these projects are enormous, probably won't reach the funding stage, let alone the detailed refinement, unless and until they know that they're getting consent out of this process. So, and I wonder, and I record this in my notes, whether Section 125A, 125.1a criteria out of the RMA would rescue it as to whether substantial progress could be thought to have been made in such a short period of time, 2 years. So, I don't know, it must have been a deliberate legislative policy, because it's cropped up again in the bill, but we'll see. The people may have something to say to the Select Committee about that. So let's start to have a bit of a closer look at the bill. I'm going to chance my arm and say that I think that the existing regime has operated quite satisfactorily within its known limitations of time, cost and rights of participation being truncated. Quite satisfactorily. However, there are some changes occurring if the bill is passed in its current form or anything like it, which I think need some careful thought by everybody who's involved. Some of the changes, while notable, should attract little controversy, and I will feel able to discuss those reasonably freely. However, there are others which are attracting high levels of controversy in the community, which I can't, in my judicial role, embark on discussion of such matters other than merely to note them. The first and quite notable difference, is the purpose of the bill that I covered at the beginning of my address. The next section of my paper discusses eligibility to enter the new process. It has some interesting changes from the current eligibility regime and has more ministerial involvement. I won't go into it in great detail, but it does bear knowing about and commenting on during the Select Committee process if people are so minded. The next feature that is a big difference from the existing legislation is the requirement for panels to process additional types of approvals alongside the RMA type matters. Now, this one is, it's difficult probably for a lot of us in our field to know quite how much is involved, because these processes have gone on within government departments in specialist ways, like in the Department of Conservation and places like that. But it could be that they involve a great deal of work on top of a great deal of work, which I'll come back to in the RMA space. And so, for instance, in summary, panels are going to have to deal with approvals, permits and other arrangements in legislation that concern wildlife conservation, freshwater fisheries, heritage, EEZ activities, aquaculture and fisheries, crown minerals and public works approvals. Now, they won't all be requiring to be worked on in every case, but you've only, I suspect, got to strike, say, 2 or maybe 3 of those additional permits or approvals or other arrangements, and there could be quite a packet of work for panels. I've talked about the Treaty of Waitangi. I've talked about the panel convener. There's a section of my paper where I describe the role of ministers, and then I come to the last section of my paper, which raises some issues and some questions about the bill, which people might like to get their minds around at the current stage of things while there's a Select Committee process running. I'm going to confine myself to matters of process, by and large. I think that's necessarily runs with my role, my judicial role. So I'm going to concentrate on timeframes for the work of panels, geographical extent of involvement of potentially affected persons, and the limited time to provide comments. So those are matters of process. So I'll start with timeframes for the work by panels, which in the bill are reflective of very similar provisions in the existing legislation. So we have a working knowledge of them now that hopefully can inform people's thinking going forward. I make an assumption while talking to you today that some projects that will enter the new system will be bigger and more complex than most, perhaps even almost all of the projects that have come through my hands as convener under the existing legislation. And I'm particularly thinking of fast-track projects of national significance. Geographical extent might be but one issue in this. Geotechnical complexity, scientific and engineering complexity, about matters of land, water and air might be other examples. And I'm just sort of, at very high level, raising those topics. Added to which is the need for the consents and approvals and permits under other legislation, which could be a big packet of work, as I've indicated. The work of panels in such circumstances, I suggest, may therefore be considerably greater under the new system than the old. From my experience in consenting generally over many years, and not just in leading the existing COVID recovery process, I worry that the quality of panel recommendations working in such tight timeframes could suffer, and that this could be a worry to ministers if the panel work is rushed and inadequately done. Perhaps some things potentially entirely missed in the course of the work. You see, ministers could find themselves faced with more work because if they feel the need to differ from a panel's recommendations, then section 25(4) of the bill provides that ministers cannot deviate from a panel's recommendations unless they've undertaken an analysis of the recommendations and any conditions included in accordance with the relevant assessment criteria. So there's a big task potentially facing ministers, and if the ministers are not being adequately assisted by quality recommendations from panels because there just wasn't enough time to do the job, then it's a worry. So, and another consequence, of course, could be more appeal or review risk and time taken up with matters having to go to the senior courts. My concerns and questions are prompted by experience determining myself some big cases in the Environment Court and on boards of inquiry and expert panels over many years. And I'm going to describe a handful of them to you here by way of illustration. I'm going to start with a series of decisions, some interim decisions and a final decision in a case where the appellant was called EYRE, E-Y-R-E, Community Environmental Safety Society, Inc. This case was one where I presided in the Environment Court. The case was concluded in 2020. It concerned an application for a very large above-ground water storage dam in North Canterbury. Issues in the early stages of the case were highly technical engineering matters, which just happened to get brought into increased focus by the Kaikoura earthquake occurring during an adjournment between tranches of the hearings, bringing home to the parties and the court in spades the geotechnical and civil engineering issues that we'd been grappling with already. One of the members of my panel was a very, very experienced big dam engineer, Russell Howie. He'd been the chair of the Big Dam Society in New Zealand prior to becoming Commissioner of the Environment Court. Now, it just happened that about 200 homes were located in what would be a flow path of swiftly rushing floodwaters in the event of a dam breach. This was an above-ground dam perched at the top of a slope that led down into this valley where these houses were. And these properties stretched for some kilometres below the site and were located largely along unsealed rural roads. So they were notably outside the footprint of the proposal, of course, but also outside of being adjacent properties, to use the phrase from the bill. People invited to comment in the bill are restricted to people within the footprint or on adjacent properties. I'll come back to that and ask a couple of questions in a moment. A strongly contributing factor to our ultimate ability to grant consent on complex conditions was the undoubted need for the parties and their experts to collaborate and engage together in conference, which they did with the assistance of court commissioners, to develop answers on issues of geotechnical engineering, civil and structural engineering, seismic assessment and design, hydraulic modelling, the quality, construction and installation of the HDPE liner, embankment design, monitoring and failure detection systems, practicality and effectiveness of emergency action and evacuation plans, and public liability insurance informed by expert input from skilled specialist insurance lawyers. It was a lot of work. I asked the question in my paper today, could this case have been resolved in 50 working days or some more, if granted in the discretion of ministers, and without extensive testing of expert evidence and expert conferencing involving some of Australasia's foremost engineers and scientists? And I really have to say the answer is no. It couldn't be, in my humble opinion. I do consider the Eyre case to be quite typical of big infrastructure cases for scale and complexity. It's not an outlier. A short list of examples of big infrastructure which could enter this process would include motorways, railways, electricity transmission lines, dams on rivers and elsewhere, coal mines, seabed mining, and some of the bigger aquaculture proposals. In 2009 and 10, I presided over a series of hearings in an appeal case called Crest Energy Kaipara Limited. This proposal was for 2 arrays totalling up to 200 underwater electricity turbines in the mouth of the Kaipara Harbour, a very large harbour in Northland, sufficient when fully operational to power every home in Northland. And you'd have to say that's a pretty laudable objective. And we on the court thought so too. Among the complex engineering and scientific issues were coastal geomorphology, that is stability of the positioning of these massive devices underwater, the alleged presence of the rare and endangered Maui dolphin, only 70 apparently being said to remain alive. They haven't conducted any GP sail racing on the Kaipara Harbour. So it's the Hector's dolphin that disrupted proceedings in Littleton Harbour on Saturday, not its cousin, the Maui dolphin. There are a few hundred Hector, there's only about 70 Maui, apparently, so we were told in evidence. The issues also included potential adverse effects on snapper spawning, it being the evidence that the harbour provides about 80% of the spawn for the West Coast North Island snapper fishery. Also potential adverse economic effects on that fishery and energy sector economic issues. So there's another biggie. So others indeed included navigation, aspects of electrical and civil engineering, Maori cultural issues, baseline monitoring and adaptive management approaches. Similar to Eyre, there were episodes of hearing and expert conferencing which assisted the case to move forward in an effective and timely fashion as opposed to hindering it, albeit that the proceeding did take nearly 2 years to work through and consent, and we were all busy through that whole period of time. We were able to grant consent ultimately on the basis of many stringent conditions, including as to adaptive management, which included a staged approach, strict monitoring of effects. They were going to start with only 3 turbines initially for 2 years, and a volunteered condition, and this is important, that the consent holder would remove the infrastructure and have the consent cancelled if the set parameters about the fishery and the dolphins could not be met. Now, a most interesting case, and I think I can say most interesting outcome. One of the more fascinating cases I think I've been involved with. But it was a major and complex case, and it needed all of these inputs to get to a sensible outcome at the end of the day. Sadly, it hasn't been built. I gather that there are maintenance issues. You might know more about this, Simon, about what's happening, but it's not been built. I gather it's hoped that maybe it'll come again at some point. But anyway, my question here today is whether this case could have been resolved within 50 working days or even some more, and without the considerable testing of many branches of expert knowledge and the expert conferencing. And really, I have to say, no, it couldn't. It couldn't. Closer to home in terms of time and topic was a fast-track proceeding under the existing legislation over which I presided concerning expansion of the Picton ferry port for the new Kiwi Rail ferries, now cancelled. These two new ferries would have been much bigger than the present ones and, for instance, hold trains in their bellies up to 1 kilometre long, snaking around inside them. Issues included not only effects of major expansion of the terminal itself, but consideration of adverse effects on the town, including for road traffic, cyclists and pedestrians, of these trains arriving at or departing from ferries. A major factor was Picton's recognised virtual maximisation of urban development, confined as it is by surrounding hills. The issues in the case were complex. There were requests for further information, nearly 100 placed with Kiwi Rail and the councils. And preparation of draft conditions for consent and consulting on them was also a major task on top of the other processes that I've just described. The case was completed by my panel and consents issued just within the 50 working days provided under the existing legislation. The amount of work and stress for everyone involved, parties, council, many types of experts, and the panel itself has to be described as extraordinary. I guess that the quality of our outputs, our decision at the end of the day, will not be tested because the project was later cancelled. But one can wake up at night and wonder whether we managed to cover everything, whether we got everything right. It seems that it won't be tested. Maybe that's a good thing. Several other COVID-19 Recovery Act projects have tested the limits of the 50 working day extended period, notably including the Hunanui Open Ocean Salmon Farm that was proposed off the coast of Stewart Island and was the subject of a reluctant refusal of consent. Finally, concerning working timeframes, I mentioned the Waterview Motorway Board of Inquiry, directly referred by the Minister to that Board of Inquiry, over which I presided as chair some years ago. This was another biggie. The new linking section for Auckland's southwestern motorway, SOTO 16, was the very substantial Waterview tunnel, but the project was much more extensive than that because it involved new roading and enhancements south of the tunnel, widening and enhancements to the northwestern motorway, and a new complex interchange of the two motorways at the same time. It's a remarkable feat of engineering, most of it designed in this building. The legislation under which we were working required the board to deliver its decision within 6 months of starting work. 6 months is merely twice the length of time containing a 50 working day deliberation period after receipt of comments. There may be some slight adjustment to that arithmetic, but I think I'm pretty right with it, and it points to a real shortness of time available for such a major piece of work. I ask the question: could the Waterview project have been resolved in 50 working days? I'm of the understanding that all parties advised Minister Nick Smith afterwards that they were severely stretched by the 6-month time frame, which was only just met. He incidentally was the sponsor of the legislative provisions, and he'd appointed the members of this particular board of inquiry, chaired by me. The Minister sought and received my own briefing after the project about matters of process, and my message was consistent with that reportedly offered by the parties, and he appeared to accept and understand my advice, that it was tough. Turning now briefly to geographical extension of invitations to comment, and reminding you that, again, people within the footprint of a proposal or on adjacent properties is how the bill is framed at the moment. So here's a couple of questions to test that a bit. And I'll use the air case again, the big water dam in Waimakariri, as case in point. So adjacent properties really probably doesn't fairly encapsulate the extent of potential effects of a proposal. And I'll offer you two contrasting illustrations of that. It would take no account of where effects can land in the air situation, where 200 potentially seriously affected properties were not adjacent, a long way from it. But if, on the other hand, all of that valley had been within single ownership, then that might have been an adjacent property, and the owner of it, not the occupier, it's just owners in the bill, invited to comment. And I really wonder if that's right. I've already mentioned motorways, railways and electricity transmission lines. These can be lengthy pieces of infrastructure covering vast areas of land within their footprints and their related corridors of effect. Kiwi Rail and NZTA are currently seeking reverse sensitivity provisions in district plans throughout the country. I've just signed off some Environment Court consent orders settling some Waikato appeals. The mapping of noise and vibration corridors extend in many places to 100 metres either side of the designated physical footprint of the infrastructure. And in countless instances are mapped as covering more than just adjacent properties, especially in urban areas. Finally, I make an observation about the period of time allowed for comments. Clause 21 of Schedule 4 allows 10 working days, and to help people without computers, panels have been making it 15. That's the same as under the COVID recovery legislation. However, I postulate that the policy settings are different. The purpose of the COVID recovery legislation was recovery from the then anticipated dire adverse economic effects of COVID. The new provisions are about fast consenting of mainly big projects. Now, it is not my place to question that policy, and I don't. But I do feel driven to observe that in comparison to the cases that I've described to you, excepting perhaps the Picton case, decision makers are not likely to have complex matters of science and engineering adequately tested and worked on and improved for quality outcomes. And I think there's a question there that might be of interest quite widely, I would hope. So thank you for your attention, listening to me on these quite involved matters. I've spared you the boring detail of a good deal of the workings of the current legislation, but if you're interested, you can have a look at this paper and or my navigation guide. Thank you.
Thank you, Judge. We might just leave you up there and
I'll
move on to some questions. Of course. Would anyone in the room like to have a go at the first one? Otherwise, I can go to online. Anyone feel brave?
I don't bite.
I'm surprised.
I only bark.
Okay, I do have one from online, and it may in fact be for Elliott, but of those projects that have been granted approval under the COVID-19 fast track, do either of you have any idea how many have actually been built or are in the process of being built?
No, is the short answer. A slightly qualified answer is, however, that we are aware of some. For instance, happily, I believe that the water impoundment device that was the subject of our first case in Northland, Matawi, I believe has been built and is supplying water for the irrigation of raspberries, and thereby boosting employment and economic recovery in Northland. And there will be others, but I can't take you to others. I should just know if that one. Elliott might know more than me.
Yeah, no, probably the same answer is that I'm not too sure, and I guess that's part of the other challenge of COVID is the once the approvals go through and the conditions have been drafted, it then falls back on the role of the councils to enforce and to monitor those consent conditions and to kind of work with the applicants to get that building. So once the appeals period is finished for us, that's kind of our role finished at that stage.
Thanks.
Thank you.
Just in terms of the greater eligibility criteria that's been proposed in the bill and the pressures that have been on the EPA in terms of convening panels under the existing fast track, the concerns are in the community that the number of potential projects that could get through that eligibility criteria may mean that the fast track process is no longer fast, surely because of the admin, the number of panels and the various processes. Do you have a view on that, either of you?
Each of us might have a view. Perhaps if I can kick off, and I'll do it in this way. Elliott told you that we've had 120 applications, and that about a third of them, or exactly a third of them, have been the subject of the standing up of panels just in the last 2 or 3 months. So the balance of them we managed to set up and set working over a 3.5-year period. And then we're faced with about a third of that number, about 40 cases, that have to be the subject of panels being set up now. I'll be quite frank and say that, speaking for myself at least, and probably also for the EPA, that has been a really, really big ask. It's been a huge task. It's dominated my working time as a glorified HR consultant for the last 2 or 3 months, at the cost of some other reasonably important and urgent work. Not easy if everything comes in a wave. Now, that situation came about because everybody leaves everything to the last moment. And so there were these 1/3 of the cases just getting their ministerial approval and order in council certification right bang on the 8th of July last year, the date of repeal, and so in the process. And so the wave, I called it a tsunami, has hit us now. So it's dominated my working situation, and it's stretched the resources of the EPA to not only support me, but also support each of these new panels that we're busy setting up at the moment in quite a major way. Now, whether it could be said that that would feed through into the fast track not being fast, it would be the duty of the EPA and the convener to do the level best to avoid that happening, and that might mean the EPA having to further resource itself up, and it's been doing that, and the convener could usefully do with having a deputy or an ability to delegate. That doesn't appear in either of the pieces of legislation. Somebody might want to say something about that. Rather long-winded answer. Anything to add, Elliott?
No, I guess from the EPA side, on my personal experience, when this all first started, I think we had a team of 6 or 7. I think now we're currently up to 16 of us. obviously mixture of resources, and also now we've got the COVID legislation, which, as I mentioned, we've got 44 applications live at the moment, and then we've got the Natural Built Environment Act, and potentially we may have the new legislation running concurrently as well.
So any plans to currently increase that staffing? Because 16 doesn't seem like very many when you've potentially got a waterfall of applications landing in the next 3 to 6 months.
Yeah, I mean, at the moment, until we know what the new legislation is going to look like, which, yeah, obviously there's still a journey to go there. There's not a lot we can resource for at this time.
Thank you.
I have been heard to utter the phrase, a victim of its own success.
Perhaps sticking with the theme of resourcing, there are a number of questions online about resourcing and whether or not you, Your Honour, or the EPA have confidence that there are enough people out there to deal with the work stream that's coming. I noted that one of the changes in the bill is that panels may be lawyers or planners. Do you think that will help? Will that result in better resourcing?
Yes, that could help. It could help. I've been limited to choosing senior specialist legal practitioners, and although I have an extensive list of such people, and many of you are in the room with us today and looking online, it's nevertheless been a big ask to find chairs and stand the panels up. So people are busy. People seem to be getting busier. Often people are conflicted, so I just have to keep working the phones and finding people. So yes, adding senior planners to the mix could help. There are some very senior and very skilled hearing commissioners in the planning fraternity, and so that could help. Panels might need to get some legal advice, some independent legal advice from time to time, if they haven't got a lawyer on the panel. But yes, it could help.
Thank you. And another question from online is, Elliott, you mentioned the potential of inviting panel nominations under the new regime. The question here is there a concern that might lead to effectively judge shopping with applicants trying to choose their panels, and does the EPA have a process for dealing with that?
No, I think all the work sits with the panel convener, and the panel convener obviously follows due diligence process as part of that.
And I've certainly regarded it as an important part of my task that I won't allow judge shopping. It's been tried once or twice, didn't work.
Thank you, sir. Anyone else in the room? Otherwise, I can keep going here. No. Okay. With the timeframes and the associated issues, you mentioned the 50 working day timeframe a number of times, and asked whether some of those very big projects could survive that process. Is there a risk that conditions will simply become a way of attempting to close holes in information if approvals need to be approved in that 50 working day timeframe? And is the EPA seeing that happen currently?
Can I answer that, Elliott? Yes. I think that that might be to cloak condition setting in too fine an outfit. There's a limit to the extent to which conditions can turn a pig's ear into something rather better. I also have a view from my involvement in consenting over a long time that you do strike some cases where the sheer extent of and complexity of proposed conditions are telling you that consent really ought not to be forthcoming. And so that, I suspect, is a question that people might want to ponder in the context of legislation which may not have provision for refusal of consents. I think that's arguable. I haven't closely examined those provisions, but it's thought that might be one of the ways that the bill addresses itself.
Thank you, sir. This one's perhaps one of the elephants in the room. I heard in a previous talk you gave, Sir, that you described the remuneration for the process as effectively making it pro bono services. Has that been a constraint to getting panels appointed? And is the change, I think, that's proposed in the bill to allow remuneration at effectively market rates, is that seen as a positive one?
Well, I'll answer the second one first, because I'm not sure that I read the bill that way. I think there's a reference, I found a reference, I've not looked at it closely, but I think I found a reference to Cabinet manual rates being used, which would actually be less than what I've been authorised to offer panel members and chairs, because the then Minister for the Environment gained an exception from the Cabinet to allow me to offer some slightly higher rates. Now, those higher rates are not in themselves, and this comes back to the first part of the question, riches untold. They're a long way from market rates, and so, yes, there is a pro bono element in it, and I'll be quite frank, the way in which I've had to deal with that has been to use the honeyed tongue and cajole people, sweet-talk people, into doing their public duty under a piece of legislation that was in the early stages to address economic recovery and employment recovery. And so I was able to sell the pro bono element of it in that way. The charity runway isn't there, I don't think, now. And so I do worry in two ways about this. First, that it may be increasingly difficult to secure chairs and or other panel members, and that can cause a delay in the process and harm the fast-tracking feature. And the second thing is this, and I have been asked some questions from Wellington, and I have provided this answer to officials, is this, that I don't think it would look good if, because of pay rates and or any other factors, it proved that a convener needed to engage less experienced people than I've been putting onto panels. So the sorts of projects that I've described to you today routinely involve some of Australasia's finest scientists and engineers, and I don't think it would be a good look in the slightest, particularly for important infrastructural projects, to have less experienced people sitting in judgment on the work of highly experienced and skilled people. It just doesn't look right.
Thank you, sir. Can I interest anyone in one final question before we wrap it up? We must have one in the room, yes.
Very silent lot, this audience.
Just related to that, I've heard the idea mooted around a standing panel, noting in the bill there's provision for appointment to the panel from iwi and local authorities.
Yep, as now.
But in terms of the third member, do you have any views on having a kind of standing pool, almost full-time chairs?
Yes and no. It might have some merit, but like every facet of our field of work, the levels do fluctuate, and so it might be that at times those people might be a bit underemployed, and at other times expected to be doing too much. So I think some careful thought would need to be given to that, and if the executive or select committee wanted to have some further thinking about that, they might be minded to ask the EPA and or myself for some assistance with that sort of process. It's an interesting thought. I don't think it's capable of the quickest or easiest of answers.
All right, well, thank you very much, Your Honour and Elliott. Thank you for the presentation, for both looking back and reflecting on the wild ride that has been under the COVID-19 Fast Track Consenting Act, which is not over.
Wilder one to come.
That's quite right, not over yet. And for looking ahead and giving us your insights where you felt able to. Thank you. It's been a thoroughly useful presentation.